Welcome back to Supreme Myths. I'm very excited about my guest today, who most of you who are listening or watching to this know is Adam Liptak, the Supreme Court correspondent for the New York Times. Adam is a graduate of Yale College and Yale Law School. He then went into private practice, both in a private law firm and then I think in the general counsel's office of the New York Times, yes. I believe. And then, of course, in 2008, he had some very big shoes to fill, replacing Linda Greenhouse as the Supreme Court reporter for the Times. As much as we love Linda, I think we can all agree Adam has filled those shoes wonderfully. Adam was nominated for a Pulitzer Prize in 2009, I believe. And if you want to learn about the Supreme Court, there is no one better in the United States to learn it from than Adam Liptak. Thank you, Adam, for being here.
Well, that's very nice of you to say, Eric, and it's great to be with you.
And you were down here a few years ago for a conference on invisible justices, and then you were supposed to come back for a conference on Justice Kennedy, but the Kavanaugh hearings went a little long. Can we agree on that?
Yeah, we had a second go-around. I remember that. Yeah. Most people do.
Yeah. Okay. So let's start with this. I would think there are a lot of challenges to covering the Supreme Court that other journalists don't have when they cover other politicians. What are some of the biggest challenges?
Well, it's a funny thing because on the one hand, there are challenges because in a sense, the court is quite secretive. It does a lot of its work in private. On the other hand, the court will say, and I think there's truth in this, that unlike the other branches, they are for the most part public in their reasoning. So that in a major decision, in an argued case on the merits, they will give birth to 100 pages of reasoning. So I remember once having a conversation with my editors that we needed to find out what really happened in Citizens United. This is like a couple hours after the decision came out. So, well, for starters, we can take them at their word. To a large extent, they're going to say precisely what they think in their opinions. So they are unlike the other branches in that regard. But your basic point is right, that a Pentagon reporter or a White House reporter is basically spending most of their time not explaining the public actions of those institutions, but trying to find out secret stuff. Whereas my job is largely translating legal materials to an educated readership, but nonetheless one that doesn't have the patience or the background to make sense of the legal jargon that emanates from the court.
I might push back a little bit later on how transparent the court's written opinions actually are, but before we get there, most of the justices do from time to time go around to law schools, give interviews. Of course, their answers are usually very perfunctory and all that, but they do that. Just at Georgia State alone, we've had Ginsburg, Kennedy, Scalia, O'Connor twice, and so on and so forth. To the best that I can tell, the Supreme Court, you and the USA Today Supreme Court reporter and the Wall Street Journal, you don't sit down with these justices and do interviews with them. Would you want to do that?
Well, so let me push back a little bit. I have interviewed Ginsburg on the record twice, Breyer, Sotomayor, Stevens.
Okay.
Typically when they have a book to peddle. But nonetheless, there have been those occasions, and they're not wholly inaccessible in other regards either. So it's not a completely binary black and white thing. But sure, I'd like to talk to them more.
Yeah.
They know where to find me.
A few months ago, there was some stuff going on in social media about their law clerks and how, some 98% or pick a number, never say anything about their justice ever that means anything for the rest of their lives. There are exceptions every now and then. Lazarus wrote a book, of course, about justice, about the Casey opinion. But overall, law clerks don't talk ever, not even unless a justice dies and they're doing a memorial. And that's almost always positive. Is that a good thing, that we never hear negative things from their law clerks?
So, again, I'm going to quarrel with the premise a little bit. A current law clerk never talks,
right? And
a recent law clerk seldom talks. A law clerk for Justice Thurgood Marshall will talk to you all day. So there's an inverse relationship between, how recently the law clerk served and how much they're willing to talk.
Right.
And so I I don't find it as and people people publish books about reminiscences of law clerks. I do take your second point that they almost always only say positive things about the justices for whom they served. And that's probably for the most part authentic. It's an important relationship with an important mentor, and you're going to feel good about it usually. And also, but it's probably a professional calculation also. What good is going to come to you from criticizing a Supreme
Right.
Court justice?
One last question about this that may get me in a lot of trouble. I don't think it'll get you in trouble, but if it does, don't answer it. So I blog with Mike Dorff, who's also a good friend of mine, and I love Mike, and I think he's great. And Mike clerked for Justice Kennedy during the Lee versus Weissman and Casey term of 1992. And if you go back in time and look at articles around that time, you will see people talking about the greenhouse effect, about Justice Kennedy. We discussed that when she was here. But there are also rumors that Mike was he was Larry Tribe's GRA, and there were rumors that he and Tribe kind of got Kennedy to change his mind from Webster to Casey. I don't want Justice Kennedy to pass away. I want him to live 20 more years. But in the unlikely event that in the sad event that he does pass away, would there be anything wrong with Mike talking about those rumors, either confirming them, putting them to rest, saying it didn't happen that way, something he'll never do and wouldn't do? But I'm not sure there's anything wrong in that. Is there something wrong with that?
So I guess you answered on two levels. One is, what understanding did he have with Justice Kennedy about chamber secrecy? And, if you make a deal with someone that you're going to keep that secret even after that someone's death, you should keep that deal. But in general, I think there's a fetishization of secrecy in chambers. And it's not really clear what it's based on. I mean, what recent events, it's based on what in other contexts is called the deliberative process privilege, that you want people to be able to speak candidly.
Sure.
And if they know that what they said in chambers while they're cogitating on something will be disclosed tomorrow, they're less likely to be candid. And I understand that completely. That diminishes with time, probably disappears at some point in time. And so unless Mike had a special private understanding with Justice Kennedy, I don't know what should stop him from telling people about their government in action.
Steve Vermeil used to teach at Georgia State, is a friend of mine. He's now a law professor at American. He co-wrote a biography on Justice Blackmun. And because he's a friend, I had some access to Brennan's file. And they're Brennan's papers. And there's gold in there for those of us who teach. For example, Brennan wrote a lot of important federal courts opinions in addition to his con law opinions. And a couple of them are mysterious as to why Brennan would have gone the way he did.
Right.
And these papers tell us a lot. As an historical matter, I think they're really important. Do you have any thoughts about how we're not going to see, Justice O'Connor's papers until 50 years after Justice Thomas resigns and all this stuff?
I mean, Steve's in an interesting position because I think he's actually the executor of these papers, in addition to having had privileged access to them, even while Brennan was alive.
Yes.
And he would go up to Brennan's chambers early in the morning and rifle through his files. That's quite an opportunity. Should Justice's papers be made public sooner? What am I going to say? I'm a journalist. Of course, I think so. And I also wonder why we treat them as Justice's private property. They were created on the government's dime. And I don't think any particular harm was done by the quite prompt release of Thurgood Marshall's papers.
Right.
I'm in favor of openness. Dean Erwin Chemerinsky, I was talking about this area generally at a speech I saw him give, and he made a statement that stayed with me, that knowledge is better than ignorance.
Erwin is very good at saying statements that stay with people for a long time. Mm-hmm. There's an obscure federal courts case called Franchise Tax Board that's really complicated and hard, and Brennan comes out against jurisdiction. And my students always kind of wonder, why is Justice Brennan, who's usually for court access, and his papers shed light on why he did that and how close he came to not doing that. And I think there are a lot of examples like that. So I agree with you. I think I agree that there's some parts of those papers that maybe should never come out if they're part of the deliberative process and all that. But harmless but important information. Anyway, one more question about covering the court, and then we'll go to more controversial matters. You mentioned Citizens United. When that case came out, I got calls from the several radio stations and media to talk about it right after it came out. And I said, this opinion's 80 pages, 100, I don't remember, it's somewhere around 100 pages all in, I think.
Well, it was about 60,000 words, which is to say about the length of The Great Gatsby.
Right, a book. And I said to these media outlets, no, I won't do it. Now, this is a long time ago. I don't think I would give that answer today. But I said, you want me to read a book between, in 30 minutes, and anybody who says they can do that, but you somehow, and I've mentioned this to you privately before, it always amazes me how very complicated Supreme Court opinions with concurrences and dissents and partial concurrences and partial dissents you get something out within a few hours of those decisions incredibly fast, and in my long reading of your reporting, accurate. How do you do it so fast?
So there are two reasons, Eric. One is that it's not a very hardworking court. There are, in a typical term, maybe half a dozen really important cases. And I will have followed them very closely, written a story on the cert grant, gone to the argument, talked to the principals, talked to the lawyers involved, read the briefs, have a pretty good idea of what the court's going to do. And I will pre-write versions of the story, including most of it, what in journalistic jargon is called B matter, sort of uncontroversial background that's going to stay true no matter what happens.
Right.
And then it's an iterative process. So I'll put up a story very fast in a big case within a few minutes that just announces which side won. And then maybe 5 minutes later, put in a vote count and a couple of quotes, and only then sit down and read. And it will take a good hour to read a major decision.
Yeah.
But we will by then have posted the bare bones news of what happened. And then after I've read it, only then does the story start to achieve liftoff, where you get some sense of the reasoning, the context, the consequences. So the earliest stories are quite thin. They're not wrong, but they're kind of mechanical. And the later ones, I hope, bring the value added that the Times has traditionally tried to bring to Supreme Court coverage.
And I think you do that. And you often have quotes from experts in whatever area of the law it's in. Do you pick those people in advance, kind of, so they're ready to go when the decision comes out? How does that work?
I actually don't use a lot of outside voices unless it's an area that I'm quite unfamiliar with, like patent law. In much of my coverage, I turn to academics and sometimes people I've gotten to know in various ways, including by their presence on blogs and social media, so that if someone demonstrates
right.
that they're actually following an area closely, sentencing law, election law, whatever,
yeah.
I may well turn to that person. But in argument stories and decision stories, the materials themselves from the court are rich enough that I don't think I need an outside voice to amplify it, and I ought to be able to say things on my own authority.
Yeah. Have there been one or two or three cases over your, 12 years now or 13 years, that surprised you the most, where the opinion came out and you went, oh my goodness, I never saw that one coming?
Yeah, I think they generally involve the Chief Justice. I'm not sure I had predicted his vote in the first Affordable Care Act case. His recent cases on abortion and DACA, I'm not sure I saw them coming.
Right.
And then the Bostock case, where the chief and Justice Gorsuch, who wrote, voted in favor of a statutory worker protection for gay and transgender people. By the time of the argument, that seemed like it was a likely outcome, but some of those cases were surprises.
For what it's worth, I was making fairly bold predictions that Justice Roberts was never going to overturn or severely dampen Roe and Casey in an election year, because that's just not the way he rolls. I'm curious you didn't mention the case that I think was maybe the most surprising case, other than maybe Obamacare in 2012, is Justice Kennedy's turnaround in Fisher versus Texas too, I guess, where he.
Yeah, that quite surprising. And I have a theory on that. You remember there were two versions of Fisher.
Yeah.
And in the first one, Justice Kennedy simply punted, didn't want to decide, not unlike his attitude in Masterpiece Cake Shop.
Yep.
And then the case comes back to the court, and it seems to me that the four most conservative justices try to force him to make a decision and put him on the spot. And I think that might have irked him. And he joins he joins the liberals. I think that was a quite shorthanded court, wasn't it?
Yes, it was 5-3. Yeah.
Yeah, I think Kagan was out because of a conflict, and Scalia had died. Is that right? I think that's right. Kagan had an SG level conflict.
Oh, so was it 5-2?
I think it might have been 4-3.
Right. Okay.
We should know this. Someone should look this up. Anyway, that's not the key point.
Yeah.
The key point is I agree with you that Justice Kennedy, who had never before voted to uphold an affirmative action program, did there. Although in quite short order, we'll have the Harvard case before the court, and we will find a way to, in essence, overturn Fisher.
There's a lot I want to respond to about that. My first reaction is I want to reach through the screen and hug you for suggesting that maybe Justice Kennedy's decision here wasn't 100% based on his good faith view of the law, and maybe some personal things, quasi-personal things were going on, because I have a lot of theories about that in the court. So I want to hug you for that. Second, I actually don't think the Harvard case is going to come out like you think it is. I think there's going to be a lot. This is the Harvard affirmative action case brought on behalf, putatively brought on behalf of Asian applicants, but brought by the same people who brought Fisher versus Texas. And it's really about white, black, not Asians. But anyway, when the conservatives see what would happen if the amicus briefs are filed, if a colorblind and gender-blind admissions system actually went into effect at Ivy League schools, they're going to find out that white males are going to be hurt dramatically. And there's a lot of data for that. And I personally have talked to admissions committee people in the elite schools. They tell me that all the time. So if that evidence is given to the justices, I'm not sure what's going to happen with that case. We may see a surprising shift, but
we'll see. Well, maybe I'll be surprised again.
Yeah, I hope so. All right. On to some current events. Are you willing to take some positions on whether you think court reform is necessary?
Ask me the question, and I'll tell you what.
Okay, let's start with this. No one's talking about this anymore because it's not as important as the other stuff. It needs to be live streamed on television. I mean, live streamed so people can see it, right? The arguments. I mean, isn't that a no-brainer these days?
I don't think there are principled arguments against cameras in the court, but nor do I think it's going to happen.
Even after this live audio that's been going on during COVID, you don't think, wow, you think they're going to go back to silence?
I think it's a 50-50 shot whether we continue to have live audio once the court's back on the bench.
Wow.
They're quite opposed to camera coverage.
It's hard to take. This is facetious. It's hard to take rights away from the American people, and I think it's going to be hard to stop this, but who knows? Of course, they might do that. More importantly, leaving aside the chances of it happening, which I think we're both going to agree are small, is there anything the Democrats can do about their perceived slight about the Garland seat? And they're not going to add one seat at him because other than me, no one in the world thinks it should be an even number of seats, even though the original number was 6. But can you see a world where we end up with 10 Supreme Court justices?
So let me start with that point. I thought an 8-member court was a terrible idea when we had that year.
You told me that.
And I've come around to think that at least when the even-numbered court is ideologically divided, it actually works fairly well. It makes them make more modest decisions. It makes them try to find consensus. The German Constitutional Court sits in panels of 8 and are appointed 4 and 4 by the two major political parties. And it's a very, very well respected court. So I've come around to your view, Eric, substantially, that an even number is not a bad idea, so long as you have ideological balance. I mean, if you have a 6-2 court, it's probably even worse than a 5-4 or a 6-3 court. But you were asking a larger question, right?
But yes, but I want to pause you there, though, because this will be the headline of this tweet unless you reveal something else. That is astonishing. Little bit of background. When Justice Scalia passed, for other people, I know you know this. When Justice Scalia passed away in 2016, and we had 4 Republicans and 4 Democrats, and yes, despite what Jonathan Adler keeps saying, Kennedy was a conservative Republican. He did have some liberal tendencies, of course, with gay rights and all, but he voted conservative, I think, 75% of the time. So we were evenly divided 4 and 4. And I had this idea, freeze it here. The end of the story is kind of amusing, I think. Freeze it here. And I wrote that in your paper, in the New York Times, among other places. And Judge Posner invited me to Chicago to do a workshop, which you've done, I think, to present this to a combination of Chicago professors and judges, like Judge Easterbrook and Judge Posner. You and I talked about this, and I think you said it was one of the dumbest ideas you've ever heard, to have an evenly balanced Supreme Court. But you also warned me about Judge Easterbrook. And you said, Adam, he looked at me like I was the next coming of Satan for an hour and 45 minutes. Everyone else in the room was against, but he would have none of it. So I want to make sure I understood this. If we could have a constitutional amendment that said we're going to have an 8, 10, or 12-person Supreme Court evenly divided among Republicans and Democrats with a statutory out, or wouldn't be statutory, a Senate rule out for independence, which I put in my proposal, so that we can get independent there if we ever found one who is truly independent. You're now in favor of that proposal? Because I'm
not going to endorse the particular proposal. I'm saying that an ideologically divided, even-numbered court has real advantages.
I'm wondering if the New Hampshire case, did you follow that, had any bearing on your feelings about this?
Do you mean perhaps the Delaware case?
I do. I'm wrong. I'm sorry. The Delaware case. Yes, thank you.
Yeah, so I mean, the problem with partisan balancing, and it sounds like your proposal tries to deal with it, is that it only lets the major parties participate, and that's deeply problematic. Mm-hmm. So the court in the end got rid of the case on standing, so we didn't get an answer to this.
Right.
But my sense is they didn't have a particular problem with limiting the number of judges of one political party in the majority.
Right.
Say on a 5-member court, only 3 can be Republicans. Right. But they did have a problem saying the other 2 have to be Democrats, or vice versa.
Right.
That someone with no party affiliation should be eligible to be a judge.
Yeah, I won't go into it, but I did have a very manageable way of dealing with that, because that was actually, I presented that proposal at 8 law schools. One of the biggest pushbacks was you're just cementing the 2-party system, and it's not fair to independents. Yeah. I definitely had a way around that, but I won't bore everybody with that. Well, I'm glad you've evolved on this issue. It makes my heart good. Is there a way for Democrats to get the Garland? I mean, Democrats, I'm not asking you to comment on this. Democrats think the Garland fiasco was a stolen seat, just pure theft. Mm-hmm. Is there a practical way for them to get it back that could possibly happen, do you think?
Well, practical, probably not. Theoretically, the Congress is free to increase the size of the Supreme Court. The size of the Supreme Court, Eric, has gone up and down over the years. Yeah. Not for a long time now. And if the Democrats had a substantial majority in the Senate and the majority they now have in the House, I suppose they could do it. In order to make a difference on a 6-3 court, I think if you do the math, you probably have to add 4 seats. That starts to be a very big court. And this is not a court that, unlike many constitutional courts around the world, sits in panels. So you wonder whether a court that big can function. Even 9 is a little bit hard. And you also have to wonder whether you're not starting a kind of tit-for-tat escalation that's going to end in disaster, because when the Republicans take over, they're going to expand it even more, and all of a sudden, it's problematic.
For the record, I don't want a 13-person court. I want a 12-person court, so it's 6-6. And then we're back to our good idea of having an evenly balanced court. Jeffrey Toobin, I think it's his book, The Nine. It might be one of his other books. Either begins or ends it with, I think he ends it, we have the Supreme Court we deserve, or something, something like that the American people get the Supreme Court they deserve. And right now, the American people are as polarized as any time in my 62 years that I've been following American politics. It's really bad. I wrote a blog post this morning about Stone Mountain, Georgia, which still has Confederate flags flying in a state park. And I have no doubt there will be serious pushback to that. I don't know on what possible grounds, but there will be. We are really polarized. This court feels to me like it's going to be not a 5-4 polarized court, obviously, but a 6-3 very polarized court. Do you think it's more or less than it used to be, the same? How do we compare across eras?
No, I think just as the American public and Congress is more polarized than any time since the Civil War, the Supreme Court mimics that. Now, I don't think that's what the American people deserve, but for a variety of reasons, ideology has become the key determinant in getting on the court. It wasn't so long ago that presidents appointed their cronies, or people would give them political benefits, or someone for the Jewish seat.
Right.
Now ideology is really what people look for, and they've gotten much better at making sure they pick people who are not going to drift. So we have a kind of ugly locked-in situation where if all you know is the party of the president who appointed the justice, you know quite a lot about how that justice is going to vote. And again, as you know, Eric, that didn't used to be the case.
Right.
Think of Souter, think of Stevens, think of Brennan, think of Blackmun, think of Warren, all liberal Republican appointees. Think of Byron White, a generally conservative Democratic appointee. Those days seem to be gone.
Yeah, and that's I've often said we need 9 Souters or 9 Stevenses or 9 Whites. Or part of my proposal, by the way, was geared to getting more moderate justices who would be harder to predict, but still more moderate, because a Republican president having to nominate a Democrat nominee will almost certainly nominate a conservative Democrat nominee. So anyway, but yeah, I wonder sometimes if the court couldn't do a little better. It's probably a pipe dream in helping us deal with this polarization by being a little less polarized itself. And maybe Justice Roberts does do some of that. Do you have a thought on that?
I think that's part of the chief's calculation as chief justice, as custodian of the court's legitimacy and prestige.
Do you have a favorite case? When I mean favorite, let me define favorite, not the result you wanted. That was so beautifully written, so wonderfully reasoned that it stands out. Or a couple?
I don't know that I'm going to come up with, some of the Kagan dissents in religion cases, for instance, I think are quite strong.
Yeah.
I think the chief's writing is almost always quite strong.
Yeah.
But I guess I don't really know how to answer that question.
Fair enough. I have a convoluted question I've been trying to ask you. Been wanting to ask you for a long time, so bear with me for just a minute. Justice Kennedy resigned from the Supreme Court in 2018, I guess, and Judge Posner resigned shortly before that, or sometime before that. I don't remember the exact time. I once wrote a post. You write columns, I write posts. That the two men were very similar in a lot of respects in their lack of fidelity to an overarching grand theory of law, whether it be originalism or anything else. I mean, Posner was a pragmatist, but I'm not sure that's a theory. But Kennedy was our most important justice, obviously, from 2006 to 2018. That's not debatable. And I assume Posner was one of the most important non-Supreme Court judges ever. Both of them predated the Federalist Society. They both came of age. The Federalist Society began in 82, 83. They were formed prior to that. And it's my thesis that we don't have a lot of, and they were both Republicans and they were both conservatives back in the day. Neither one was considered that so much when they retired. It's my theory that coming of age before the Federalist Society is very different than coming of age after the Federalist Society. And Gorsuch, Kavanaugh, Alito, I'm wondering what you think about that.
I think I have problems with every step of the analysis.
Okay. That's Adam's nice way of saying you're full of crap. All right, go ahead.
The Federalist Society is very important, and it is a real mark of ideology. But the people who supported Posner supported him as part of the Reagan Revolution in moving the courts to the right, and as then an adherent of the law and economics movement, and also just a brainiac and a leading law professor who they thought would do a great job. Kennedy was a second choice, a third choice. And really what they wanted was that same kind of model I was talking about a second ago. Bork, antitrust, brainiac, solicitor general, part of the Reagan Revolution,
Right.
The SG who fired Archibald Cox. And only because he failed did they turn to a different model, a kind of old school Sacramento lobbyist with highfalutin theories, but not especially rigorous ones, sort of cosmic theories about the law that I don't associate with the way Judge Posner thought about things. The pragmatist on the court during the Kennedy era was O'Connor, who was trying to figure out what the workable solution to a societal problem is. Kennedy, although the swing vote, was a maximalist. And when he was with you 110%. Whereas I view Judge Posner for most of his career as a true common law judge, as someone trying to figure out what the right resolution of a given dispute was.
I agree. First of all, I agree with everything you just said. I don't know if that's the point I was making, and I'm sure I didn't make it well enough. Well, let me ask it this way. I don't know if I can think of an exceptionally bright. I guess there are people who would take issue with how smart Justice Kennedy was. Not many people would take issue with how smart Judge Posner was. But that's sideways to my point, which is an exceptionally bright conservative judge today, or someone who wants to be a judge today. Even someone like Michael McConnell, who also kind of a little bit predated the Federalist Society, and I think has a view of judging that is very humble and very, but anyone eligible to be on the Court of Appeals today in a Republican administration is going to have to toe an ideological line, not a political line. And I think those are different things. Can you imagine any Republican judge saying I'm against originalism getting on the court? I mean, that wouldn't happen, right?
Right.
What I'm trying to say is,
I agree with you that to get on the court, one, it's very important to simply be a member of the Federalist Society and active in it if you want to be a Republican appointee. And two, you have to sort of kiss the book on things like hostility to the administrative state and abortion rights, and even judges who say, like Jeff Sutton, voted to uphold the Affordable Care Act, that seems to have been disqualifying for a very fine judge. Even Justice Kavanaugh, who may be too clever by half, decided that the case was not ripe for decision, got a lot of criticism as insufficiently attentive to the importance of striking down the Affordable Care Act. So there does seem to be a felt desire for a kind of ideological purity from the people who appoint Republican judges that is probably a product from the Federalist Society writ large.
and I think you're looking at it from the perspective of the people who will nominate and confirm the judges. I was actually looking at it from the perspective of the judges themselves, and I still will, I think, go to the mat on the idea that the Federalist Society changed a lot about how judges on the right act, speak, and view the Constitution. But we don't have to beat a dead horse. I just think it's important. I just always thought it was interesting that at circa 2017, although Roberts was the chief, Justice Kennedy was obviously the vote that mattered the most, and Judge Posner was still riding high as a Court of Appeals judge, and neither one of them had any use for originalism, which I think wouldn't work today. It just that kind of attitude would not work. I had a call from a Third Circuit Court of Appeals judge, a phone call, who said he heard a podcast I did about originalism. And he told me that he liked what I said. And then he went on a 20-minute rant. I never met this person in my life. He went on a 20-minute rant about his colleagues and how all they want to learn about is what happened in 1789 or occasionally 1868. And it was driving him crazy. And he didn't understand why they were looking for answers. And what he said was all the wrong places. And he is definitely seeing he told me he's seeing a major change.
But do you think, Eric, that there are that many committed originalists on the Supreme Court? Certainly Thomas, certainly Gorsuch, probably Barrett, but not the chief, not Alito.
Well, I was going to ask you that question, Adam, but in a different way that I wasn't sure you were going to answer. When you say committed originalists, you don't have to react to this. My view is there are no committed originalists on the Supreme Court. I've written more blog posts, articles, and a book on how Scalia and Thomas, their overall jurisprudence, is as living constitutionalists as any other judge. Scalia struck down 135 or 140 laws, something like that. There's a very small percentage of those where he actually did an originalist analysis. Do you want to react to that comment that I just made?
I think both that people use originalism opportunistically, and that even the use of originalism is fairly malleable. It can lead you to results in one direction or the other, particularly given what level of generality you choose to interpret the Constitution. I don't disagree with any of that. Maybe I should have said, rather than committed, avowed.
Yes, I agree with that. I agree. I want to go back to something you said, which was that Justice Kavanaugh was clever by half or something like that. I was teaching, I'm teaching Roe and Casey in con law now, and students are asking me, what's going to happen and all that. I thought I don't remember if you reported it, so I apologize, but an underreported aspect of Kavanaugh's confirmation hearing was when he said he agreed with Justice White's concurrence in Griswold. So just to bring people up to speed on this, Griswold is the case where the Supreme Court struck down Connecticut's anti-contraception law. It was in 1965, I think, and it formalized the right to privacy, which eventually gave birth in Roe. Didn't mean that as a pun. That came to rise in Roe. But Justice White's concurring opinion in Griswold does not rely on the right to privacy, as you know. It relies on a kind of rational basis. The means ends don't fit here. Kavanaugh doing that. I want to ask you, but do you think that was wildly intentional? I mean, do you think he thought about it beforehand and decided his strategy about abortion was going to be, I'm not going to commit to anything. I'm not going to disown Griswold because that gets me in trouble. But I'm going to rely on White, and then of course White dissented in Roe. So when Kavanaugh votes to overturn Roe, he can say, "I said all along that I agreed with White." And what do you think of that?
I don't think, on an issue as important as Griswold and Roe, any comment made in a confirmation hearing is not carefully thought through.
Okay. Is there something you'd rather law professors do better, con law professors, to make your life easier?
To make my life easier, no, and that shouldn't be their goal, to make my life easier. I find a lot of law review writing to be too long, too formal, too theoretical, and for my purposes, not sufficiently engaged with the pending Supreme Court docket. I'm surprised by how many law professors sort of at the end of the term start to learn about what the Supreme Court did rather than follow the arguments as they unfold through the term. But I mean, part of the problem is that the law review format has a million problems with it, but one of it is that it's much too slow.
Right.
I mean, you want to be reacting to what's going on in the world now, not a year or 18 months from now.
I was surprised last week. I had Keith Whittington on, And I love Keith. I don't agree with him about much, but
Me too.
he's a great guy and very thoughtful. And he was, I've written a piece called Law Review Follies that goes through a lot of the problems, one of which is you submit an article in February, it may come out the next March if you're lucky. Keith told me that peer-reviewed journals, because he's a political scientist, often also take that long or longer, which actually shocked me. But then again, he had no answer when I said, yes, but at least you don't have second-year law students deciding on the merits of those pieces as opposed to experts.
Yes. I actually would think that peer review takes time. And if you had nimble editors, students, or others, you ought to be able to post something. I mean, I write something in the morning and it's on the web.
Right.
Like immediately. That's not, I mean, there's also a superstructure to law review articles that is driven by a pedagogical need because students are learning how to blue book stuff, and also by an attempt to demonstrate to people who will vote on your tenure that you have this ability not only to make a point, which you could probably make in 5 pages, but also to survey the landscape and put in all the footnotes. And so it has various goals, but most of those goals are unrelated to the conveying of fresh information promptly to interested readers.
I love the way you put that. I think all of the goals are unrelated to fresh information. Even when the online law reviews first began, I would say around 2010-ish, give or take, maybe a little bit earlier, I used to have good luck submitting to the elite law reviews. Harvard published a piece of mine in 5 weeks, the Harvard Law Review Forum or whatever it was called. And that was a time-sensitive piece because it was, it doesn't matter. They published it quickly. Even that's gone, Adam. If I write I
didn't know that.
Yeah, if I write a 6,000 or 7,000 or even a 3,000 or 4,000 word piece, and I've done a bunch of these in the last 3 years, it can take 8 months now for an online law review to get your piece up, which is one of the reasons, and I've had running battles, that's too strong a word, running discussions on Twitter with a lot of thoughtful law professors about blog posts. I can set, so I blog for Dwarf on Law. Mike is, Mike runs it, but we kind of work on it together. But I can tell Mike I want to publish a piece on Monday, write it on Sunday, and it's up. I mean, that can happen.
Yeah.
I have no, other than op-eds and essays, I have, in newspapers, I have no real other way of doing that. Even Slate and Daily Beast and all of that could be a 2 or 3 day, 4 day difference. But the year wait of the law reviews is causing havoc, I think, for a lot of tenure committees. Because when I came up when I started in 91, got tenure in 96. Back then, we just accepted that law review articles will be out of time. I mean, they won't be fresh because of. But now people, like as you know, want it yesterday, and it's a hard balance between timeliness and thoughtfulness, I guess.
Yeah, but the internet ought to take care of some of these publication issues.
You would think. I mean, Harvard and Chicago both have blog. Or Harvard had a blog. I can't. I published in it a few times, and that was a day. I would send them in the morning. It would come up the next day. That's not going to be a life-changing article, but it could be a pretty good piece about a current event. I hope more of the elite law reviews do that, because I think that's one place. Maybe the New York Times might not want them to do it, but I think that would be a good place for it, I think. Is there anything you would change about how journalists in general report on the court? And this will be one of my last questions.
Well, occasional coverage of the court has serious shortcomings because people don't have the background to know what they're talking about. So it's not unusual for people to report that the Supreme Court had ruled on something when all they did was deny review, deny cert.
Right.
And that kind of elementary mistake, or reading too much into a procedural move, could be cured if more people had a little bit more background in covering the court. But on the other hand, you could also make the case that the Supreme Court is way overcovered. There are maybe 25 of us with hard passes who cover the court more or less full time.
Right.
That's a weird societal misallocation of resources when most of the law that we live under is made by state Supreme Courts and federal circuit courts who can issue major decisions that are entirely unreported. Meanwhile, some minor Armed Career Criminal Act case comes out and 25 people are, writing modest stories about them, but nonetheless writing essentially the same story all at the same time.
And speaking of the 25 of you, or however many they are, one of the things I've noticed that I find really nice, especially in this age of polarization, is from what I can tell, you and Robert Barnes, who is the Supreme Court reporter for the Washington Post, and Jesse Braven, Dahlia, all the national Supreme Court reporters, you all cite each other. I mean, you all point to when Barnes writes a good piece, you have no problem. He does it all the time, but it's one that you particularly think is important. You tweet it out and you support it and all that. It's very much a team, isn't it?
It's a very collegial group,
yeah,
and a lot of fun to work with, and people tend to do the job for a long time. And we also don't have a lot of scoops to be chasing after, so there's no particular reason to be hyper competitive. But one thing I miss, Eric, during the pandemic is that the press room at the court is a really fun place to hang out, and we can also talk to each other about matters of such trivia that not only are they not worthy of a New York Times story, they're not worthy of a Twitter, of a tweet. But we're fascinated by all the workings and the eye rolling on the bench and the odd turns of phrase. So it's a lovely, welcoming bunch of people. And yes, we do. When someone writes something smart, I have no hesitation. I'm eager for people to see it.
Yeah, and I think they all do it. I think all of you do it, from what I can tell. Yeah. Those of you on Twitter. All right. I think this is. Thank you so much for this. I think this is one of my last questions, if not my last question. So I'm going back to something you said, which is that in some ways the court is one of our most transparent public bodies because they are required to give public reasons for their decisions. I'm not sure they're required to, but they do give public reasons for their decisions, and they do that in all major cases, obviously.
In argued cases,
yeah.
If there's a second set of cases, and maybe this is where you're heading, that people call the shadow docket, where their rulings on emergency applications, which can be very consequential, are often accompanied by no reasoning at all, and I think that's deeply problematic.
Sure, and I think Will Bode called it that. Maybe I don't know if he called it that first.
Yes,
but Steve Vladeck has done
he's generally credited with the term.
Yeah,
yes.
Yeah, and Steve Vladeck has done good reporting on that too, I think.
Yes.
But I guess what I want to ask you is, so as you know, much of my career has been devoted to demystifying the court in many different ways. But one of them is that I don't think the justice, I'm trying to ask this carefully. I think these are hard cases often and hard decisions and some that really get to the justice's heart and soul, abortion, affirmative action, whatever it is, campaign finance. When they care a lot, it's important to them. And like all of us who make hard parenting decisions or hard professional decisions or hard grading decisions in my case, I don't always know my true motivation. And we know that with governors, presidents, senators, we really don't believe much of what they say. I mean, this is my main point here. We call governors, presidents, senators, mayors liars all the time. When this is one example, I'm not asking about a specific example, but the general idea. So Justice O'Connor in Adirond, an affirmative action case, describes a previous affirmative action case, Metro Broadcasting, as an outlier and as a veer in doctrine. And she's just demonstrably wrong about that. It's just false. It's not true. We can prove it. Metro Broadcasting was not different than other cases. It was the culmination of a line of cases. When I bring that up to people, they say, well, she made a mistake, or she didn't say exactly what it was. I say, no, she knew what she was doing, and it was false. And then people get mad at me. I'm not allowed to call the justices liars. I'm not allowed to say they were negligent in how they treated this prior case, or the clerks were, whatever. And then Susanna Sherry, compound question, friend of mine from way back, wrote this fantastic piece a few years ago about the justices as celebrities. I think you covered that. Are they too much like celebrities? And are we, not you, but law professors, too easy on them?
So on the first point, I'm sure there are instances where the justices were sloppy or worse. But as a general matter, I think they are entitled to be taken at their word, that what they say is what they mean. And I think most of us should be entitled to do that, to that courtesy. If there's something demonstrably wrong, I wouldn't, first of all, ascribe it to a calculated falsehood. I ascribe it to negligence.
Mm-hmm.
But we should explore these things. I don't dispute any of that. And then as to whether the justices enjoy their status in the world too much, because they're treated like royalty at law schools and bar associations and so on, and worse yet, at Federal Society and American Constitution
Yeah.
Society events. I think you could make the argument that they should take some more cases and make some fewer appearances.
Yeah. They have 4 law clerks each now, I think. They used to get 3, is that right? Like, and they decide half as many cases they decided in the 50s and 60s, I think.
Right. So last term, I may have the number wrong. It was the smallest number since the Civil War. I think it was 56 signed decisions in argued cases. We're not on track to do much better this year.
Yeah.
If you think, you divide that by 9 and then take into account that they each have 4 law clerks, then, so the merits docket is very slow. They've been doing a lot of work on the shadow docket. It takes a lot of work to do the cert docket. They are dealing with last minute stay requests and death penalty cases. They have stuff to do. But I think their taste for public appearances is in some tension with the size of the docket. They as I say, maybe they should take a few more cases.
Justice David Namias of the Georgia Supreme Court, a Scalia clerk, has said publicly on many occasions. I don't know how many opinions he writes a year, but it's, I think, close to 100. I mean, it's way up there. And he talks about how they write 12 or 11 or 10 merits opinions a year.
Yes, each, they're not even.
Yeah, he's very articulate about that.
Now, of course, there are people who would be worried about the court taking on more cases.
Yeah, you're looking at one of them.
Exactly. When the Chief Justice was a White House lawyer, he wrote a bunch of funny memos. He's a witty writer, and he wrote that only apropos the long summer break the justices take, that only school children and Supreme Court justices get the summer off. But then he said, but at least the Constitution is safe for the summer.
Right. I can think of no better way to leave than on that note. Thank you, Adam. This has been really fun. I really appreciate it. Thank you for
Thanks for having me, Eric.
Thank you very much.